Yes.
My Lords, Agrevo. I submitted to your Lordships this morning on the basis of paragraph 23 of Warner Lambert that really the Agrevo case was in response to overbroad claiming, and that was really the origin of the doctrine of enforceability in the European Patent Office, and it's taken on to a degree a life of its own. And I just wanted to make that point good by showing you just a few parts of Agrevo. I don't think it's necessary for this purpose to read all of it now, but it's tab 4 of First Authorities Bundle, starting at page 65. It's perhaps useful just to think about how this case arose procedurally as well before the Technical Board of Appeal, which you'll find at page 2 of the decision in Roman, big Roman 3. The patent was for a pharmaceutical compound, and it was intended as a herbicidal compound. And there was a debate about whether one of the substituent groups in the basic structure would be such that if you made the relevant substitutions, there would be herbicidal activity to be expected. And the Board of Appeal said this in paragraph 3. In a communication pursuant to Article 110, the Board of Appeal questioned that the application documents contain sufficient internal evidence to render it credible that all claimed compounds have the state of herbicidal activity. During the appeal proceeding, the Board further informed the appellant that it might be prepared to acknowledge an inventive step. The subject matter of the present application were limited to chemical compounds, which, on the basis of all the available evidence, the possession of herbicidal activity was credible and indicated the extent to which this might be the case. Further communication, the Board referred the appellant to D9 and informed him that the compounds as claimed in the application could well be regarded as being products of conventional synthetic methods, if therefore the problem solved by the present application could only be seen as providing novel chemical compounds, and the compounds proposed and claimed as solution to the problem could well be regarded as obvious. And then there were claim sets filed in response to that. And the way in which that matter was left in the before the Board of Appeal was reflected in a later paragraph of the decision, 2.6.7 on page 89 of the appeal bundle, where the Board picks up on that point. The appellant had been informed about the insufficiency of the evidence submitted by him in the present case, and also been given ample opportunity either to restrict his claims to such a group of compounds which the Board was prepared to accept the credibility of their alleged herbicidal activity, see point 3 above, that's the one to which I've just referred, or to provide further evidence, either by test results or by other means, that in the present case the kind of substitution of the phenyl ring R3, which was the focus of analysis in the case, is not relevant to the herbicidal activity. Despite these clear and helpful leads, which the Board was not obliged to afford, neither appropriate amendments nor further evidence were forthcoming. And the Board said, for these reasons, on the basis of what evidence there is in this case, the Board is not satisfied that substantially all compounds now being claimed are likely to be herbicidally active, since it's set out above in the points which are marked, but I don't think we need to go to. Only those of the claimed chemical compounds could possibly involve an inventive step which could be accepted as solutions of the technical problem of providing further herbicidally active compounds. Subject matter of the main request extends to compounds which are not inventive and therefore does not meet the requirements of Article 56 EPC. Over the page, since the Board has indicated in points 3 and 2.67 above that it would have been prepared to accept the presence of an inventive step on the basis of a limited number of the claimed compounds possessing the promised activity, whereas the decision under appeal found that herbicidal activity of these compounds would have been expected by the skilled person. The Board finds it appropriate to make the following observations, and it then goes on to make observations about the scope, essentially, of the claims and the structural element. So what this case really was about in our submission was a situation where a patentee was trying to maintain, both at first instance and before the Board of Appeal, a claim of undue breadth, where the Board of Appeal had said, look, really, you have a chance even to show us that your claim is not of undue breadth, actually provide some test results, even later test results were contemplated, show that this was not merely speculation. And the patentee said, well, no, I'm not going to do that. I'm not going to provide any test results at all. I'm going to stick with where I am. And the board, in those circumstances, one might say unsurprisingly, said, well, you haven't substantiated that you have got activity across the scope of the claims. And so this, we would respectively submit, is the court, is the technical Board of Appeals response to what might be called unremedied biogen insufficiency. And one could perfectly well understand that, because as is established in much of the case law, the idea is that one should enable the invention across the scope of the claims.
But there was no lack of enablement across the scope of the claims, because the whole point was you could make all of the claim compounds by conventional synthetic methods. The objection was that they were therefore obvious if the only technical problem that was being solved was the provision of further triazoles.
Oh, indeed.
By contrast, if the technical problem being solved was provision of herbicidal activity, then it wasn't credible without further evidence that there was herbicidal activity across the breadth of the compounds. So the decision was that the claim as framed was obvious, or at least included compounds which were obvious.
It included compounds which were obvious, because at least among the compounds in question were compounds that it was obvious to make, or at least where there was no invention in making them, because they were effectively just a matter of writing those claims down. In that case, I'm not quite sure whether they were made, but in any event, one could have made them by simply writing them.
And that was the point of the D9 reference, because it was the textbook that told you how to make them.
Absolutely. The textbook said, make these. So the patentee was justifying its invention on the basis that they had made a link between the relevant compounds and the indication for which they were of utility. They had not made that link in a sufficiently comprehensive way. My point is only in relation to this case to say that this case isn't authority for the proposition that in the case of every new chemical entity, it is always necessary to do a plausibility analysis in order to establish whether or not the claims are or are not insufficient. This case obviously only relates to obviousness, but aggravo obviousness. But it is said on the other side that this is setting some standard that means that it's got to be done across the board in every circumstance. And we respectfully submit that this case doesn't go that far. It's a limited case on its facts for the reasons that my lord has given. So that is the position on the authorities, and I think I've summarised my legal submissions on those points. If I could then turn to the other aspect of the appeal, the second aspect, which is then to focus on the patent, its disclosure, and what the judge held about it. And I will pick up some of the points in the authorities as we go along on that. But it is perhaps worth bearing in mind some of the points on the patent. And if I can just show my lords that, and the key passages upon which we submit attention should focus. And we can take it from the application in Supplementary Bundle 2. And picking it up at page 3 of the bundle, title of the patent, lactam-containing compounds and their derivatives as factor 10A inhibitors, reference to the field relating generally to lactam-containing compounds and derivatives thereof, which are inhibitors of trypsin, like serine protease enzymes, especially factor 10A, pharmaceutical compositions containing the same methods of using the same as anticoagulant agents for treatment of thromboembolic disorders. There is then a description on page 7 of factor 10A, starting at line 21, and a reference to activated factor 10A, whose major practical role, generation of thrombin by the limited proteolysis prothrombin, holding a central position. And there is a description of that, and over on page 8, therefore efficacious and specific inhibitors of factor 10A needed as potentially valuable therapeutic agents for the treatment of thromboembolic disorders, and that it's desirable to discover new factor 10A inhibitors. And so the reader is being told that that's the direction of travel of the invention and the patentee. The invention is then summarized on page 9 of the bundle as providing novel lactam-containing compounds and derivatives thereof that are useful as factor 10A inhibitors or pharmaceutically acceptable salts or prodrugs thereof, and various methods of provided. Description of methods are provided in that context. Then there comes a detailed description of the preferred embodiments, and there is a great deal of work there reported, including work specifically on apixaban, of analogues made of the various lactam compounds. And I'll show my lords in a moment a kind of aid memoir which will help my lords in reading the disclosures, at least of one of the key parts of the patent. My lord has already drawn attention to the fact that apixaban appears as one of a number of compounds in claim 8. The basis for that is found on page 70 of the bundle, 68 of the document, where there's a reference to another preferred embodiment, and the compound is selected from that group, and that group is one reflected in the claim where apixaban also appears. Coming on to the utility of the compounds, that it starts at page 170, and we would respectfully invite attention to that. The judge was somewhat critical of this in the light of the evidence. We respectfully submit not really to be somewhat overcritical of it for reasons I will explain, but the patent explains that the compounds of the invention are inhibitors of factor 10A and are useful as anticoagulants for the treatment or prevention of thromboembolic disorders in mammals, and then it explains what's contemplated by thromboembolic disorder. And over on page 171, the effectiveness of compounds of the present invention as inhibitors of factor 10A was determined using purified human factor 10A and synthetic substrate. Rate of factor 10A hydrolysis of chromogenic substrate was measured both in the absence and presence of compounds of the present invention, prima facie saying work had been done both in synthesis and in terms of measuring effectiveness. Hydrolysis of the substrate resulted in the release of PNA. It was monitored spectrophotometrically by measuring the increase in absorbance at a particular wavelength, and the results are then expressed as inhibitory constant KIs, and you see that the factor 10A determinations were made in that way with a calculation set out for how that was to be determined. And the patent then goes on to say compounds tested in the above assay are considered to be active if they exhibit a KI of less than 10 micromoles. Preferred compounds of the present invention have KIs of preferred of less than 1 micromole, more preferred less than 0.1, and then you get to the still more preferred of the present invention have KIs of nanomolar level. And the patent says, using the methodology described above, a number of the compounds of the present invention were found to exhibit KIs of less than 10 micromolar, thereby confirming the utility of the compounds of the present invention as effective factor 10A inhibitors. Now, pausing there, just in relation to the point that's made on the nanomolar stroke micromolar point of efficacy, the way that matters developed at trial, and I'll be told that this is incorrect, is that BMS's case was that it was not necessary for efficacy for there to be nanomolar potency of these inhibitors. It was the generics case, which was ultimately accepted by the judge, that in order for therapeutic purposes and indeed other purposes, it was necessary for there to be nanomolar Ki. But the point that BMS was making was not that the patent had to disclose a specific level of Ki in order for the plausibility test as applied to be satisfied, but that there was information from which it could be concluded, or reasonably concluded, that apixaban was likely to have relevant efficacy, whatever that was. Now, what is said against us in relation to this point, about, or running a new point that wasn't run, it's actually almost putting it the other way around. It's because the generics case was that a Ki needed to be at nanomolar level, that BMS's position is, well, all right, if you say that that's what the standard would be thought to be, then on the assumption that a skilled person reading the specification would consider that there was material from which it could be properly inferred that there was sufficient efficacy, then it would logically follow from that that would be nanomolar, if that was what it was ultimately determined to be the thinking in the art. That's not running a new point. What that is saying is that it doesn't matter for this purpose what the precise level of efficacy would have been thought to be.
This I don't begin to understand, I'm afraid. Now, I'm aware that your clients were directed to serve, and did serve, a statement of their case on plausibility prior to trial. So please, could you take us to the paragraph in that statement that you are relying upon as founding your present argument?
Yes, one moment. Corban Law, tab 17. And the point, well, in fact, my lord needs to read from paragraph 7 on to paragraph 12. And sorry. And the point that we make is actually encompassed in paragraphs 10 and 11 of that statement of case, which is that the skilled addressee would appreciate from example 18 of the patent, teaches how to synthesize apixaban in gram quantity sufficient to enable analysis. Apixaban was the most promising candidate disclosed in the patent. Skilled addressee would infer from the facts and matter set out in paragraph 10 that apixaban was one of the compounds that had been tested in human factor, in vitro model, and found to be an effective factor 10A inhibitor. There was no part of our case that in order to be an effective factor 10A inhibitor, it had to satisfy a particular level, or at least the disclosure had to satisfy a particular level. Our case was more fundamental than that at trial. It was to say, look, here we have disclosed something that we have prima facie tested and prima facie found successful, regardless of where precisely that its Ki value is to be found in the range of Ki values on page 170 of the patent. We were not saying that the Ki value had to be a given micromolar. We said the Ki values in the patent indicate that the compounds are considered active if their Ki is less than or equal to 10 micromolars. We're not committing. I'm sorry, Mark.
Do I understand from what you've just said that it is not your case that the skilled person reading the application would understand that apixaban had nanomolar potency?
Let me put it in the other way around. What the skilled person would understand in reading the application is that BMS had made apixaban, that it was reasonably to be inferred that it had been tested and found to be effective. And what our case at trial was that in order for a skilled person to consider that it was effective, it would be sufficient for the skilled person to think that it was less than 10 nanomolar potency. Sorry, 10 micromolar potency. But the generic said, no, that actually skilled people would expect a more demanding standard. So our position is, well, all right, if the skilled person reading the specification concludes from the specification that apixaban is effective, then the conclusion would be it had met whatever standard it is required to meet in order to be effective.
I'm not understanding this. So the judge has found, as I understand it, and correct me if I'm wrong, the skilled person, on the basis of their common general knowledge with which they read this document, is looking for nanomolar potency as the criterion of efficacy. And as I understand your answer to my previous question, you don't dispute that if they look for that in relation to apixaban, they don't find it.
Well, subject to this point, what they do find is a description on page 120 of a cascade of preferred levels of potency.
Indeed.
And we would respectfully submit that let's assume that a skilled person concluded, I know this is a matter of dispute, I'm going to persuade your lordships of it, that apixaban was sufficiently effective to be taken forward for further testing. The natural conclusion of that, if one puts that together with the common general knowledge, is that apixaban would be in the more preferred category of potency. But what is the most preferred category of potency? That is nanomolar potency. And so on the assumption that a skilled person is coming at this patent with the mindset that a successful molecule needs nanomolar potency, if they also see something from which they can conclude that there has been success, the consequence of that would be that they would think, well, it must be in the most preferred category. The point, my lord, is that the description on page 120 is not excluding nanomolar potency. It is encompassing nanomolar potency and saying that nanomolar potency is the most preferred level of potency for a compound to have.
So that amounts, as I understand it, to a submission that by a process of putting 2 and 2 together, and you say making 4, the skilled person would think that apixaban had nanomolar efficacy. But that's precisely the case that it is said wasn't advanced below.
Well, the case that wasn't advanced below was in a sense looking at it from the other direction. Because what the generics were saying was this: you need to find evidence showing nanomolar potency before you can conclude from this specification that BMS had discovered that of apixaban, so that the skilled person would have to conclude of apixaban that it had a potency in that level, and then in consequence of that, say, now I recognize that that is why they must have made so much of it. Our point is exactly the opposite point, because we were not contending that it was necessary for a skilled person, that a skilled person would necessarily think that nanomolar potency was necessary for efficacy. It was the generics case that nanomolar potency was necessary for efficacy, to which, in a sense, the response is, well, all right, if you say that, and the judge has held that nanomolar potency is the standard of efficacy, if a skilled person sees a patent saying something is efficacious, then they're going to think it's nanomolar potency. They're going to think it's in the highest category of potency rather than, as it were, merely in the less than 10 micromolars. So the point that my lord should bear in mind on this point is it's not that we are running some kind of new case. The case that we are running was not relying on, as it were, the starting point being a determination of nanomolar potency for apixaban. Our case was that the material about apixaban indicated naturally that it was likely to be efficacious for reasons that we will explore in a moment.
I'm still struggling to understand your position on this. Let me put the question one last time and see if I can be clear as to where you stand. Do you accept that this court can and should approach your case on the footing that it is not part of your case, that it is plausible that apixaban would have nanomolar Ki, nor that that is said to be disclosed explicitly or implicitly by the application?
It's our position that it is not necessary for this court to approach this appeal on this basis, that the specific level of Ki for apixaban is a consequence of the way that we're putting the case. It's not the starting point for the case. And if I can just explain that a little bit more clearly, because my lord is looking puzzled. Our point in relation to the case is that the patent discloses work that has been done, prima facie testing that has been done, which we submit prima facie indicates likely efficacy. Although we accept that there may be other explanations that a skilled person would conclude on the basis of that material, the overwhelmingly most likely explanation that a skilled person would conclude from the amount that was made was that that was the one that BMS thought sufficiently good to take forward into further work. The precise level of Ki which a skilled person would assume that product to have depends, it is true, on what the common general knowledge would be as to what the expectation was of what an effective product would need to have. So if you say, let's take an absolutely explicit claim, let's suppose that a patent says, I have tested apixaban, and I have found specifically that it is sufficiently efficacious to take forward to further work. Let's take that extreme situation. We would submit that at that point it's the end of the case, regardless of whether the skilled person would think that that apixaban had a Ki of micromolar or nanomolar. On the findings of the judge, we accept that the skilled person would naturally think that a product that had thereby been found to be effective had nanomolar Ki. That's because the skilled person would expect nanomolar Ki to be associated with a claim to efficacy.
But does the skilled person, this may be an inappropriate question, but does the skilled person assume that the skilled person's own expectations about the level of efficacy or level of potency are the same as the ones that are being adopted by the application?
Well, my lord, that's actually a very good question, and it conceals a technical point beneath it. As I submitted this morning, there are potentially a number of different criteria that are required in order for what might be called ultimate efficacy to be obtained. It's got to be sufficiently potent, there's got to be specificity, druggability, and so forth. Let us suppose that a person looking at this says, well, I can see that actually, although I would think that really, for most factor Xa inhibitors, you would need to have nanomolar Ki in order for there to be sufficient potency. But I can also see that that let's suppose that something that didn't quite reach that level actually had fabulous bioavailability or particular specificity or whatever, then it may be able to, in a sense, compensate for its being slightly less good on that dimension with actually qualities on another dimension. And reading the patent, you'd say, well, I can see that the patentee actually completely in accordance with expectation says the most preferred of this set of criteria for potency is nanomolar Ki. That's why they've put that at the center. But what they're doing here really is a usual kind of, if I may put it like this without discourtesy, patent attorney language of taking what is actually a core and then doing a periphery around it. And the skilled person saying, well, you know, I can see why they would want to preserve the option, because it may turn out that it's on the boundary, for example, or one test might determine that it had nanomolar and another test might determine it was a slightly different level of potency.
How do you square that answer with what the text actually says? At page 170,
yes.
172 in the bundle, it says compounds tested in the above essay are considered to be active if they exhibit a Ki of less than or equal to 10 micromolar.
Yes.
And then further down, a number of compounds the present invention without specifying which were found to exhibit Ki's of less than or equal to 10 micromolar, thereby confirming the utility of the compounds of the present invention as effective factor Xa inhibitors. So is it not plainly putting forward its criterion of efficacy as 10 micromolar?
Well, what it is putting forward is a criterion of efficacy of less than or equal to 10 micromolar. What it is not saying is that this is this is a threshold that will be acceptable specifically for therapeutic use of factor Xa in every case. But if and insofar as the patent can be understood as suggesting that there is a preferred, highlighted analog that is sufficiently good to be taken forward, then in our respectful submission, it's entirely true. That statement remains true of apixaban. It may be said that what this patent does is to set too generous a standard of therapeutic efficacy in that passage. But that does not detract from the fact that there is a specific disclosure of apixaban as having been made, as I've said, in quantities rationally explicable on the basis that it is not only within that class of less than 10 micromolar, but a much preferred compound of that class.
Can I ask you a question which has been puzzling me? If it is the case that before this application, apixaban had been tested and had been found to have nanomolar Ki, why does it not say so?
Well, I can't refer, my lord, to evidence
No,
on,
I mean
on that
your
matter.
experience of patent application. Why would an application for a patent not put forward the best case? I mean, why would it hide it in this obscure language?
My lord, we respectfully submit that it's not hiding it in obscure language. What it is saying is...
Well, let me be blunt. It doesn't say in this passage on 172, some compounds of the present invention, including apixaban, found to exhibit KIs of less than... No. If that were the case, why? What disadvantage could there be to an applicant not to say so?
Well, again, I'm not able to answer that question on the basis of evidence.
No, I'm not asking you to give evidence of something you don't know about. I understand that. But just as a matter of theory, why would somebody not say that if it were the case?
One reason is that they may simply not think it necessary to do so. Patents are drafted
They've not been shy in putting forward 400 pages of application.
Well, that's a fair point, but they're pages of different kinds. They're pages of synthetic chemistry, and my lord, what one might say, at the time that this application was filed, it was not regarded as a requirement under relevant laws to put forward data of this kind in various patents. This was a patent that was filed in originally, I think, as a United States patent. It is perfectly possible.
Well, this is a PCT.
I accept that it's PCT, and there was a United States application that was a priority document originally for it.
Incidentally, on that question, while the thought occurs to me, I'm assuming from the fact that what we've got in the bundle is the PCT rather than the EPA spec, that the two are identical.
I'll check that, but I've been assuming that as well. Because
I mean, that seems to be the working assumption that we've already been proceeding on, and it's obviously convenient.
Yes.
Not least because it eliminates the hypothetical possibility that there might be some typos in the EPA.
Yes, well, exactly. Yeah, strictly hypothetical. But to come back to my lord's question, which is of course a good question.
As a matter of logic, there's only two possible answers. And these of course are hypotheticals. There is no evidence, but logically there's only two possibilities. One is apixaban was not tested, and that's why there are no test results. The other possibility is it was tested, but for reasons of commercial strategy, it was a deliberate decision was taken not to put the test results in.
Well, there is a third possibility, which is that there wasn't a deliberate decision not to put the test results in, but that it was
negligence. I suppose logically that's a possibility, yes.
That was not what I was going to submit. No, not negligence, but simply not thinking it was necessary to do so. Now, in our respectful submission, it was a patent filed in 2002. It's true that the law of plausibility and so forth has developed very significantly in the last years.
Although Agrevo predates it by some years.
Agrevo was earlier. It was not a matter that was objected to, at least as I understand it, by the European Patent Office. They didn't say, well, because you don't have this data in your application, we're going to reject your further processing of the patent on the ground that it doesn't comply with Agrevo. The patent was
well. You say that, but we notice that the claim as granted is limited to apixaban, and one assumes that the reason for that is because objection was taken to the wider claims.
Well, the point is
are you telling me that there was a voluntary limitation without objection?
I can't say that, my lord. I'm not sufficiently up on the file on that point. But the question is a slightly different one in my submission, my lord, which is this. My Lord Justice Nugee asked, well, why didn't you put the data in? relating to apixaban, and that is a good question. But my point in relation to the prosecution is that the EPA, regardless of the fact that this patent was limited in this way, did not say, well, because you don't have any data in there relating to apixaban, we reject it on that basis. And
well, I'm sorry, but can I ask you a question about that? Because if we turn to tab 2, we find the granted patent.
Yes.
And we find from the remarks on page 443
Yes.
that this is one of those patents where we are told the file contains technical information submitted after the application was filed and not included in the specification. So not only is this a case where the granted claim is much narrower than the narrowest claim originally applied for, but also it appears that it was on the basis of technical information submitted after the application.
Yes. And my lords, of course,
possibly including test results for apixaban.
Indeed, but if anything, that makes my point, or at least it makes this aspect of my response to Lord Justice Nugee, which is that the patentee could reasonably take the view that they were not obliged to include test results in the original specification, not because they were deliberately concealing them, but because under the law under which the patent was originally drafted, if it was drafted in that way, it was not considered necessary to include that kind of material. And for the fact that the material had not been included originally, not to be the subject of criticism, if it was possible to submit further test data to confirm that a narrower specification was appropriate and was not itself speculative. So in my respectful submission, although this is not obviously an ideal situation, if this was an ideal situation, none of us would be here. This is a situation, in a sense, caused by the absence of what my lord has identified as being something that could have been done. We accept that. But the question of law, really, for my lords, is whether the fact that it hasn't been done means that we lose our patent entirely.
Well, yes, but you see, I come back to the logical possibilities that I identify. And all we have is a statement that some unspecified compounds were tested. Now, we have to take that statement as being true, but there is no statement that says that apixaban was one of those tested. And therefore, we have to proceed on the basis, do we not, that it is possible that the reason why there is no data for apixaban is because it wasn't tested.
My lord is right to say that that is a possibility, but it is a very unlikely possibility, reading the specification as a whole. And I'll come on to that on the point of highlighting, if I may, which is the next point. Can I just park that question for the moment, and then answer it slightly more fully when I've shown my lord the material. So if we then go on to the examples, there are many examples. Example 18 is the one upon which we particularly rely. That's on page 222 of the appeal bundle, which shows the manufacture of apixaban and the particular analog. And your lordship see the point that's been referred to as the 3 gram point, which somewhat plays it on page 224, line 25, where what happened here was that not only was a very significant quantity made, it was also subject to an additional recrystallization step. And our submission is, and supported by the judgment in this respect, that what would one envisage having been done with an unusually large quantity of apixaban, not testing it? I mean, it really stretches credibility to assume, or for the skilled person to assume, or for this court to assume, that apixaban was not one of those tested when it was the most prominent of those made. And if I can just show my lord the aide-memoire to indicate the level of prominence, so you don't have to trawl through the material in the patent for yourselves, you will find that in Supplementary Bundle 1, Tab 2, at page 5 of the appeal bundle. Just to explain to my lord what this was an exhibit at trial as part of a case relating, which we don't proceed before my lord, as part of a case relating to what you could draw from the nature of the analogues that had been made. And just very briefly to explain what's going on in this chemistry and then show my lord the point. The core of the analogues in question is, as you see there, with a bicyclic ring. R1, in this case, in the case of apixaban, is a carboxamide. That's the bottom right-hand corner. R2 is methoxyphenyl, and you see methoxyphenyl actually used as a substituent in a number of the other variants that were made by BMS. And substituent 3 is the lactam, which you will see at R3. And again, you will see that among the substituents that were tried, lactam 1 was I think the most common of the lactam substituents in that group, and one sees that just for interest reflected in the instances in question in this group. The R2 instance, the R1 instances on page 18, where you see the carboxamide moiety featuring as the second most frequent after the trifluoromethyl, and 4-methoxyphenyl as the R2 moiety being the, as it were, the top pick, if I may put it like that, of the R2 instances, and the lactam 1 being the top pick of the lactam instances as R3, just so that my lords have the chemistry on that. But coming back to the key point on this, if you look at the amount synthesized, which is in the right-hand column, the example 18 amount, it really stands out quite strikingly. If you look at the rest of the pack, one sees that in some cases there wasn't any obviously synthesized. In the case of a number of the others, only a relatively small quantity was synthesized. And we, respectfully, in agreement with the judge, contend that that is something that the skilled person would have noticed. It is, in a sense, outstanding, in one sense, and it is something from which reasonable inferences could be drawn. And we respectfully disagree with what my lord has suggested, that looking at this specification as a whole, concluding that of all of the analogues described, apixaban had not been tested, would be a very odd conclusion to reach on the basis of this disclosure as a whole. The natural conclusion for a skilled person to reach would be that apixaban would be the one upon which most work had been done. And I'll show my lords what the judge said about it and why he was, in a sense, insufficiently generous to the disclosure and what a skilled person would consider about that disclosure. And in fact, it's convenient to do that right away, but useful also to keep the patent open.
Well, why don't we finish with the application and then go to the judgment?
Oh, yes. Well, those really are the core points to be made on the application. I've made the point about apixaban featuring in one of the claims, and my lord's made the point that it was one.
Can you just take us to
yes.
the claim?
I'm so sorry. It's claim 8, and it is the one at the bottom of 377, so 379. Making sure that I've got that right.
So, this morning I made the observation that I thought it was 20 or 30, but looking at it again, that must be an underestimate because this goes on for slightly more pages than I realised.
Yes.
So, how many is in that group?
I'd be told that it's 74, but
Right.
I
Thank you.
disagree with that. But
Which one is apixaban?
it's the one on the bottom of page 379 of the bundle. 1,4-methoxyphenyl, 7-oxo, etc. And you can match that
Your example.
up with the heading on example 18.
Thank you.
I don't think I need to go to the patent separately. So if I can then take matters up with you, John.
Yes.
Oh, I thought my lords, I think I've addressed you sufficiently on example 18. Are you intent on that? Some doubt as to. In case I haven't, full synthetic.
Yeah, it tells you from soup to nuts how to make it.
Tells you how to make it, tells you it's being made in these unusually large quantities, tells you there's a second crystallization, which is itself unusual. I think I've made the points on that. So if we go to the judgment at tab 8 of the core bundle, I can take it up at page 139 of the appeal bundle, where the judge analyses the material in support of the plausibility point. It starts at paragraph 158, and there's reference to the page 170 points that I have made. 159. The judge says, counsel for BMS submitted that although it was not explicitly stated which compounds were tested, the skill reader would assume all the synthesized compounds, or at least the vast bulk of them, had been tested. The basis for this was said to be that 652 described the invention as being about lactams. Apparently could only have tested compounds that were actually made. There was no point in making them unless they were going to be tested. Counsel for BMS did, however, accept that the skill reader would infer that not all compounds that were tested would have been successful. Some might have failed. I agree with this. And then he says, in my view, BMS seeks to read far too much into this sentence. On its own, it would not be understood as standing with any reliability of anything that it says, which is that some identified compounds have been tested with activities at the level indicated, and that utility for some broader class, quoting the patentee's opinion, be inferred. Just pausing there, we respectfully submit that there is an element of unreality about that, bearing in mind the unusual nature of apixaban. Because what the judge appears to be saying is, well, I can't really even tell whether apixaban was tested. That is an unreal submission in relation to a patent that is about the making and testing of pharmaceuticals, and of which an unusually large amount was made of one of them. What the right approach is to this evidence is to say that, of course, I would expect among the analogues that have been tested, even though I can't be sure which were tested, in particular of those where it is not clear how much was made, one thing of which I can be absolutely sure is that apixaban was made and tested. And to simply say of this patent, oh, well, you really don't have any idea, or that you can't draw any inference about any individual compound, be it apixaban or any other, and that there's simply no information, as the judge said, and that some compounds might have failed. There's no way for the reader to know of any particular compound whether it was good or bad. Now, on that point, I'll come back to that because that relates to the 3 gram point. But while it is right to say that BMS did not maintain a case that page 170 on its own was something one should look at and was conclusive in relation to plausibility. The approach to it should have been that this indicated, together with the material in example 18, that it was highly likely that apixaban had been successfully synthesized, had been worked on, particularly, including the specific reference to the second crystallization, and that it had been tested. So against that background, what one needs of objection is looking at the teaching in paragraph 170 in relation to making and testing in isolation from the rest of the disclosure about what was actually made, which is the point about the example 18. So the next point is described as the 3-gram quantity point of apixaban. And I do say that is a somewhat tendentious way of describing it. It is true that we rely on the fact that it was made in 3 grams, but we also rely on the fact that other compounds were not made at anything close to that level, so that this was a standout from the patents. The second point that we make, and
The judge accepted
the judge
that,
accepted that
164.
point. The judge accepted that point, and the conclusion from that we say was again not justified, but he accepted the fact that 3 grams had been made. The point is not so much that, though. The point is that it was not only made, but unusually made. Now, the judge also accepted that, in that he said that it was the most of any compound reported to have been made by some distance. Now, that is also true, but my lords have seen, we're not just talking about, it was made, twice as much was made. We're talking almost an order of magnitude more than many of the compounds that were synthesized. And in our respectful submission, it would have been right to say that it was not only the most made of any compound by some distance, but it was very unusual in this respect. Paragraph 166, the judge rightly says that there was no disclosure of why the patentee made that amount. We submitted, and we submit to this court, that the reader would infer that it was because early results had been favourable and the patentee wanted to take work on the compounds forward. And pausing there, that is a reasonable inference from the specification taken as a whole. The purpose of the patent was to identify compounds to take forward. Why would one not infer from the patent which discloses the greatest quantity that it was that, among others, but at least that had been selected for, or that had been sufficiently promising to take forward? But it's not just us saying that this is at least a possible conclusion from the specification. The DMPK experts, that's the pharmacokinetic experts, who gave evidence on this, were agreed that this was possible, with the further work being possibly second species pharmacokinetics or early toxicology. So if one's thinking about this, what one's thinking is a skilled team thinking, wait a moment, there is a reasonable inference from the specification that this analogue specifically had been made, tested, and found sufficiently promising to take forward, not just necessarily for further testing, but pharmacokinetics. That's a fairly long way down in the pharmaceutical chain of development. My lords will know that one has to do pharmacokinetics, one has to do toxicology and so forth in order to determine whether the drug is druggable. So what this was, in our respectful submission, indicating naturally to the skilled person was that this was a product that had been taken, that early results had been promising, and that the patentee wanted to take work on the compound forward. Now, one thing that we have been criticised for is that, oh, well, this is only the patentee's view. It was just us who were saying it. But this is a research-based pharmaceutical company disclosing in a specification that they were, in a sense, getting ready for the next stage. Why is that not prima facie credible material upon which a person could conclude that this was
Mr.
likely
Alexander,
to
I'm a
be
little
a
puzzled as to
trial?
what submission you're making to this court, because what we have here is a statement by the judge that there's 3.07 grams made. That's common ground, and just read it. He accepts that it's the most by some distance, and he accepts that it sets it apart because the other exemplifying compounds there's much less made. He then goes through the evidence as to the possible reasons. So he refers into 166 as to what the evidence of the DMPK experts was. He refers in 167 to the evidence as to possibilities for it being an intermediate or a thrombin inhibitor. He goes through the evidence of Dr. Camp in 168 and 169 about reasons, and then Dr. Redshaw's evidence in 170. And he then reaches a conclusion based upon that evidence that while the skilled person would notice this large quantity and notice that it stood out, that there was no, in the absence of any data, the skilled person would simply not know why the patentee had made such a quantity, and the reasons other than factor XA inhibitory activity are real possibilities. Now, why is that not a finding of fact by the judge as to how the skilled person would interpret this specification, based upon the expert evidence?
It's not a finding of fact. In the sense of a finding of primary fact. What it is applying, we say incorrectly, is in two ways incorrectly, a standard of what is required from a specification as to the indication that it contemplates.
No, I'm sorry. My question was obviously insufficiently clear. Of course, there are two other dimensions to the inquiry. As you say, there's the question as to the level of plausibility, for want of a better expression, that one is looking for, and that's a legal question. There is also the question of interpretation of the document, which is also a legal question. However, what the judge is doing here is looking at reasons in the mind of the skilled person reading the document. And that is not a question of law, that is a question of fact based upon expert evidence. And the second sentence of 172 I'm putting to you is that he has there made a finding of fact as to what reasons the skilled person would conclude might or might not explain this large quantity.
I accept that as far as it goes, but let's just unpack that point a little bit further. What the judge says is, lacking any data, one does not know why the patentee made such a quantity.
And reasons other than factor XA inhibitory are real possibilities.
I'll come on to both sections. So I'm not shying away from this. Quite the contrary. We rely on this passage. The skilled person does not know why the patent made such a quantity, but we respectfully submit that it is a reasonable inference that they made such a quantity because early results had been favourable. That finding should have been packed in with this conclusory finding. Turning to the second part of that sentence, reasons other than factor 10A inhibitory activity are real possibilities. True, it is. They are real possibilities. But the judge had previously found that none of the possibilities in question were more likely possibilities than the inference that a skilled person could reasonably draw. That the reason that that quantity had been made was because it was regarded as favourable, and the patentee wanted to take it further. So although it is right that those findings were made by the judge, what he didn't do was put them together with his other findings, which if he had put them together and said, okay, I agree that the patentee, that one doesn't know why, but it is a reasonable inference that, and that there are real possibilities, but I do not think any of them are more plausible possibilities, more likely possibilities that a skilled person would conclude. That would have been a complete, or at least more complete finding, which would have reflected what he said in the early paragraphs. What he took was the kind of negatives from the early paragraphs, namely the fact that you don't know, without actually making, or at least summarising, the positives from those paragraphs, namely what the actual what reasonable inferences were. Now, again, if matters had been absolutely explicit, none of us would be here. But what in our respectful submission one can't do is simply look at the absence of material without looking at the same time at the material from which reasonable inferences can be drawn. So my point on that part of the judgment is not that the judge has gone wrong as far as he has made that statement, but that is an incomplete analysis of the facts, even as he found them in the earlier paragraphs. And the significance of it is this. This aspect of the case is, as the judge rightly said, one which is relatively free from hindsight. And the point is this. The material is in the specification, with all of the toing and froing on the arguments on what would or would not have been plausible. You can kind of reconstruct matters. This is not a hindsight matter. This is something where you can look at the specification and see what are reasonable inferences from it. So this is actually a positive part of the case. And the judge was, we respectfully submit, wrong to say it was a very weak point. He said it can't go further than the patentee thought that apixaban was promising. But look at the finding that the observation that he made in paragraph 166, accepting that it was possible that the further work intended being second species pharmacokinetics or early toxicology. If you say, well, it's simply assertion because the patentee thought that apixaban was promising, again, that is an incomplete description of what went on. The patentee thought it was promising, or at least it's reasonable to infer that they thought it was promising, on the basis of having made and tested apixaban. It's not simply an assertion of
well, can I ask
unsupported assertion.
Can I ask you about that? Because one thing's puzzling me about this. So, I presume you would accept that, generally speaking, with these kind of chemical reactions, you don't know the yield you're going to get in advance, and there's no indication in example 11 that the synthesis was carried out more than once.
Did my lord mean?
And so what you have is one synthesis yielding at 68% yield, I think it is, 3.07 grams. Now, you have to make it before you can test it. Now, if the hypothesis is that you made 3.7 grams because you have already tested it and found successful results, where's the first synthesis? There's only one described. This would be perfectly logical if they'd done a first run and made, let's just say, 300 milligrams, and then they'd done a second run to make 3.07 grams. But that's not what the specification says. It says one run, 3.07 grams.
Okay.
And therefore, if it was tested at all, it was some of the 3.07 grams that was tested.
Okay.
So how can you infer that it's knowledge of positive results from those tests that leads to the decision to make 3.07 grams?
Well, there are 2 points on that. First, we respectfully submit, that is, submitting the specification to really an unduly critical approach. But secondly, what one doesn't know is whether these were the only syntheses that were undertaken. Example 18 sets out a synthesis which then yields ultimately, albeit by 2 routes, a total in aggregate of 3.07 grams as a result of the ultimate recrystallization. One might say, well, why were they doing a recrystallization at all to improve the...
For the same reason
purity?
you do it always, which is to improve your yield.
Indeed. But my point is this: you can't say, well, because this example indicates, this example, as set out here, indicates an unusually large amount that was made, that this was the only synthesis that was undertaken by the patentee, even of this compound. Indeed, one might say that it's not particularly likely that it was the only synthesis undertaken of this compound. But my point, my lord, is that your lordship's point is in a sense seeking to undermine the first step of the argument, namely that one can conclude anything about the utility or potential value of the product from the amount that was made on the basis of
Well,
synthetic
you're
reproductive.
trying to extract from the data in the patent the proposition that the reason why 3.07 grams was made was because there'd been prior favourable results. But that can only be true if a prior quantity had been made. And yet that's yet another absence from the text.
Right. Well, yeah. I will think about that point, because it's not a point that's been advanced previously, but we'll think about that. Our initial point on it, though, is that it is the only one that is subject to an additional recrystallization step. It's unusual in that respect as well. It may be that for other reasons the patentee thought that this was particularly promising and made more as a result. One can't tell from this specification what the position is, but what one can tell in my submission is that this was something from which it would be reasonable to infer that early results had been promising. And on the point that my lord has put to me, in our submission, that wasn't a point that was made by the experts. I'll check that, but I don't think that was a point that either of them were making. They made different points. One of them was that making apixaban as an intermediate on the way to making something else.
Well, you say that, but the judge's
was
summary
a possibility.
of the evidence of Dr. Redshaw was that judgments could not be made about a compound's qualities from the amounts made. Now, so there was certainly evidence, according to the judge's summary, that you simply can't infer from the quantity of 3.07 grams that that's been done because it's favourable. And all I'm doing is giving a specific logical reason why that is so.
Well, in our respectful submission, what the judge was saying was that Dr. Redshaw maintained her overall position under cross-examination, that you couldn't make judgments in that respect, in that paragraph. Our submission is that insofar as he found or proceeded on the basis that one should only take into account the fact that one does not know, in the sense of definitively know, why the patentee made the quantity and other reasons than factor 10A inhibitory activities are real possibilities. That doesn't provide the full picture. But our overriding point on that, as my lords will have appreciated on the legal measure, is that this material ought to have been regarded, even applying the Warner-Lambert test, as sufficient to show that there was some reason for thinking that the product would be efficacious. The law in our submission is tolerably clear that there doesn't have to be conclusive reason to suppose that it's likely to be efficacious. We would respectfully submit that if there is material from which it can reasonably be inferred that this material was likely to be efficacious, that satisfies the Warner-Lambert test. That was the purpose of Lord Sumption making it clear that the test could be satisfied in a number of ways, and the points 3 and 4 in paragraph 37 of the judgment.
Yeah, so you rely in particular upon the statement you don't need experimental data at all.
Yes, and our submission is that this is, even if my lord is against me on the point about the factual findings and so forth, our submission is that this is enough. If there is material in the patent from which which the inference can reasonably be made, even though there may be other inferences that could be made from that material, none of which are more plausible than that inference, that satisfies that test. That is, in our submission, a proper proposition of law, and it is saying, well, the judge ought to have concluded that this material, taken as a whole, together with the material indicating the general efficacy in 170, satisfied the test that the Supreme Court had set in Warner-Lambert, and that there was put it in the language of the case, a genuine, real technical contribution that was disclosed by the patent as a result. And the judge, just coming back finally on this point, the judge's approach to Warner-Lambert was to assume that it adopted a much stricter standard of what was required for plausibility of a patent of this kind than paragraph 37 of Warner-Lambert actually provides. And that is the point right at the end of 172 of the judgment, where he refers to the bare assertion point. What he does not do, in my submission, is go through the other parts of the test in paragraph 137 in Warner-Lambert and determine whether or not there is or is not some material from which an inference can be drawn, or why it is the case that this would not be regarded as making a relevant technical contribution. So we respectfully submit that not only did the judge not apply the right test, the test that he applied was applied incorrectly, even on the basis of the facts that he found, those that we say he should additionally have referred to in paragraph 172 of the judgment. So that is, in substance, our case on that aspect. Can I then come on to the testing point? Before I do that, there is another point that we refer to in our skeleton, which is where the judge says BMS's points fail individually and their whole is no greater than the sum of their parts. Since there's no plausibility on any meaningful factor 10A, binding the patent is invalid. And then he made conditional factual findings. We respectfully submit that the mistake that the judge made on that point was not to look at the quantity of apixaban and inferences which could be drawn from apixaban, inferences that could properly be drawn from that in the context of the teaching on page 170 and the direction that the patentee was indicating it was taking and the purpose for which it was making these products. If he looked at those all together, he would have said, well, actually, I've got to look at 170 and example 18 together. If I do look at them together, then they support the fact that there is some material from which a conclusion of plausibility can properly be drawn. So the final point on this aspect, on clear and easy tests, paragraph 222 of the judgment, page 148. The judge says he accepts BMS's contention that it would not have been difficult or burdensome to test apixaban for its factor 10A inhibitory activity, and if that such test was done, a very good level of activity would have been found. The same applies to selectivity and to bioavailability. Pausing there, one might say, well, actually that indicates that at least with respect to apixaban, the patentee had made a genuine technical contribution. It was not a speculative contribution at all. It was a technical contribution of a valuable pharmaceutical, where all you would need to do to determine that it was in fact a potentially valuable pharmaceutical was do easy, non-burdensome tests to test the activity, and both for selectivity, both for activity, for all three of activity, selectivity, and bioavailability, those tests would have found that they would have confirmed what the patent was saying in that respect. But in paragraph 223, this is where we say that the judge misunderstood what Warner-Lambert was requiring. He said, the fact that I accept that BMS's factual contentions about testing does not help it. In the absence of making some showing of plausibility based on one of the other matters relied on the teaching on 170, the 3-gram point frequency, etc., the ability to test cannot get BMS any further than the patentee in Warner-Lambert. Provides as at a maximum the sort of encouragement plus ability to test that the Supreme Court rejected, as I set out above. I said a maximum because my analysis above means there's not even any encouragement concretely referable to apixaban. We respectfully submit that that is an unrealistic evaluation of the specification as a whole. And it is not our argument. We were not saying that this was an encouragement plus ability to test case. We were saying this was a situation where the patentee had identified in a reasonably clear way a particularly attractive compound out of the range that it provided, from which it could reasonably be inferred that the patentee had done work on it which gave the patentee confidence in it, and which a skilled person could readily test to satisfy not only the threshold test of potency, but the tests of selectivity and bioavailability as well. And if one steps back and asks, well, has the patentee provided any contribution to the world as a result of what they have done and what they have disclosed? We respectfully submit that the answer to that is clearly yes.
Well, can I ask you this question? Given the way you just put the case, why do we not find, when we look at the application, a claim to apixaban on its own?
Well, again,
it's just one in a list of 74, which are not differentiated one from another in the claim.
Yes, I accept that, and I don't know why the claim was framed in that particular way. It may have been thought that it was appropriate to take groups of pharmaceuticals, groups of analogues that had made changes of various kinds.
But you see, if apixaban stands out, was outstanding, to use your earlier word, because 3.07 grams were made of it, an order of magnitude more than anything else. And the reason for that was because the patentee thought that apixaban was especially promising. Then the logical thing to do would be to put a claim into it.
Well, that may be, but that's not always what happens in the case of pharmaceutical patents of this kind or others. One quite often sees pharmaceutical patents where there is, as it were, conventional medicinal chemistry, which claim either a marcouche, or they claim, initially in an application, claim a marcouche, or they claim list of potential products with individual substituents. It's not uncommon in my submission, if I'm not giving evidence here, for the analogue that turns out to be the one upon which the patentee or others focus to be not to be claim 1 or claim whatever it is of a patent.
No, frequently it's claim 22 or claim 57, but it's there.
Indeed, it may be, but it's there as well. It's true that it may well be that there are reasons why you don't claim it in this way, because if you have too many claims, you're charged more. I mean, I really don't know why. There could have been an individual claim I think there are some jurisdictions where once you get to a certain number of claims, you've got to pay extra in order to have even more. So that may be a reason why people put pharmaceutical claims together. I just don't know. But my point, my lord, is that, again, this is a very, we would say, hypercritical approach to say, well, why wasn't this done? Why wasn't that done? It loses sight of the fact that what was done was that we made and disclosed a really valuable pharmaceutical. And in such a way that it was...
Would the skilled person bear in mind the absence of a specific claim as part of the overall assessment, the holistic approach that you've been advocating?
It might be one factor, but in my submission, very little can be drawn from that. Claims at an early stage of application are quite often broad, non-specific. They aim to cover a great deal of ground where people ultimately cut down. Sometimes they are framed in the way of marquage, sometimes they're framed by way of individual pharmaceuticals, sometimes they're framed in functional terms. I mean, there are all sorts of reasons, all sorts of ways, probably some of them related to the style of particular patent attorneys drafting, why a claim set might be put in a particular way.
Well, that's right, but I mean, it doesn't really meet the point that it's a factor that the skilled person could give some weight to, along with all the other factors.
My lord, it is a factor. We respectfully submit that, as against the contents of the specification that or the description that I've been through, from which we say really that the patent must be deriving the technical teaching from the application, it's a relatively low-grade factor.
Can I just ask this one further question? As you've been developing this argument, it struck me that it has something in common with a circumstantial case. In this way, you say, well, it may be that each individual component of the argument doesn't of itself get you over the line, but taken together in combination with one another, they are capable of leading to the conclusion that you wish. Is that a fair analogy?
It is, and it's reflected in the way that we put it in our skeleton, less elegantly, but that it's important to look at all of the factors taken as a whole, rather than simply look at them individually. One of the mistakes for which we criticise the judge, with all respect, is that he looked at this in a very sliced-up way.
Yeah.
And he then came to the conclusion that, having looked at it in this sliced-up way, none of those factors taken collectively work. But our point is that you actually need to look at them together at the outset. And your lordship is, of course, right. That is like a circumstantial claim. We would perhaps put it slightly higher, or slightly differently, because circumstantialists suggest that it's a matter of evidence, where you've got lots of individual pieces of evidence. Here, really, you've got pieces of specification that are perhaps individually, any given page or paragraph isn't enough. But if you take the specification, as a whole, and what the skilled person would conclude from it, then we say our case is made out. Yeah. So the final point on paragraph 223, where, just coming back to this point, the judge says that the maximum, because my analysis above means that there's not even any encouragement concretely referenced We respectfully submit that's not right. There is encouragement referable to apixaban, but this is a much more than encouragement plus potential of further testing. This is a situation where the patentee has asserted, and I use that in a non-pejorative sense, has said, this is what we have made, this is what we are likely to have tested, and I've been through it at length the inferences that it's reasonable to draw. So this is not a case in the context of encouragement, not a case to which the encouragement plus ability to test jurisprudence applies. Final point, which I think really is encompassed within all of the submissions, is a failure to step back and consider, well, what really is the application of the law of plausibility doing in this case? Is it really operating so as to, for its purpose, namely to exclude unduly broad protection and or to deal with speculative or armchair inventions? We respectfully say, no, it isn't, and that should have guided the judge in his application of the law. It is said that this involves a superadded approach. That's not our point. We don't suggest that there's a superadded approach. You've got to kind of do a separate check on purposive application. If the law is applied in the way that I have urged upon my lords in relation to particularly those passages in 170 to 172, that will give effect to the purposes of the law. If it's applied in the way that the judge did it, it won't give effect to the purposes. It will be a kind of formalistic approach to try and exclude patents which actually do genuinely make a valuable contribution to the state of the art. So that is why we say that that's something that is a good discipline in a case of this kind, to think about it in that way, and if you do, then it supports our submissions. So unless I can assist my lords further, those are our submissions.
Well, Mr. Alexander, you've been commendably focused in your submissions and have therefore not detained the court, and we are obviously grateful for that. But I want to be sure that I've fully grasped the extent of your reliance upon the contents of the application. You took us on a whistle-stop tour of the relevant passages in the application, and there is no criticism of you at all for doing that speedily. On the contrary, we are grateful. But I want to be absolutely confident that I've accurately understood the key points that you're really relying upon. Because if I've understood the thrust of your argument correctly, when push comes to shove, you are really relying upon two key passages as making your case, as you would rightly emphasise, read together and not individually. So it's the passage on page 170, and it's the disclosure that in example 18, that apixaban has been synthesised by the route described, including a secondary crystallization, to yield 3.07 grams, and that being read in the context, whereas you showed us from the helpful table, that's much more than anything else. And really, that's the core of it that you rely on.
There are two aspects that I rely on. That is one aspect, and that is a very important aspect. But we say that that is linked to the disclosure on page 170, which, although it's of course not conclusive of the points, is suggestive of the fact that example 18, the product would have been made and tested, because that's exactly what...
Yeah, it's reading those two passages together.
So my point is that what this court should do is to read 170 and example 18 together, and once you read them together as a whole, your lordships should reach the conclusion that we're urging upon you. Those are the two key points. Of course, there are other points I've drawn my Lord's attention to, the general introduction and so forth as to the purpose of the invention. Those are not the...
Yes, we mustn't overlook
You
those,
mustn't overlook
because
those
provide the
those are not the key
context.
points. But in terms of the test of the Supreme Court, some reason to believe, I mean, just epitomise it in that way, the combination of 170 and example 18 do provide some reason to believe within the framework of that law.
Very good. That's helpful. Thank you.
If I've been too brisk on...
No.
No.
No, I just wanted to be sure that I hadn't missed some part of your argument.
I didn't think that would be a criticism.
Yes.
My Lords, I should be addressing you on the law. Mr. Tappin will be addressing you on how the law applies to
Very good. Thank you.
the documents. My Lords will appreciate we're fierce competitors. Well, our clients are fierce competitors, I should say.
I'm sure both statements are true.
Possibly. My Lords, there are three principal themes found in the case law, which we will see when we get to it. I mean, the first, my learned friend mentioned, is that a patentee, of course, must disclose its invention to the public. This is the heart of the patent system. Inventors disclose their technical advances for the public good in exchange for a monopoly for 20 years. And of course, after 20 years, that technology then becomes available to the public. And it's not permissible to describe, we say, large numbers, several millions of compounds, several hundreds of compounds, it doesn't matter, large numbers of compounds, and then not to disclose which ones are useful and for the intended purpose and the technical reason why they are useful for that purpose. As Lord Justice Jacob put it in a case, the best place to hide a book is in the Bodleian Library. And failing to reveal your technical contribution, if you have one, is not consistent with your obligations of disclosure as a patentee. Now, my Lord Justice Arnold anticipated my second submission, which was we don't know in this case why there was a failure of disclosure. The patentee has not explained why the data relating to apixaban is not in the specification, and we are not in a position to know whether they hadn't in fact tested apixaban at the filing date or whether it was a choice to withhold the data that they had. But in a first-to-file patent system, the reason doesn't really matter. We are concerned with what the specification teaches us. My learned friend, on a number of points, said that all these policies about armchair inventions, but we just don't know whether this is an armchair invention. We don't know if apixaban, at least in respect of its activity, whether apixaban was tested. And it's not, of course, just apixaban in isolation. It's the 74 compounds disclosed in the application, along with the large classes that were disclosed. A question for my Lord Justice Nugee about why. I mean, why would a patentee do this? I mean, of course, I don't know what went on. Like, nothing I say applies to what BMS specifically did in this case. But as a general matter, when you put a patent into the patent office, you are, of course, alerting your competitors to an interesting area, and you don't want to put more material than you have to, as a matter of commercial practicalities. And in some cases, patentees may sail too close to the wind, on the wrong side of the line, and so forth. So the first, I mentioned three themes. The first theme is the obligation on the patentee to disclose its invention. The second theme is that a patent must disclose a real technical advance, not just be claiming an arbitrary selection from that which was known or obvious. And we'll see these when we get to the cases. And the third theme, which you've already seen in Warner-Lambert, is that the mere assertion that a compound has a property which amounts to a technical advance is not sufficient. A patent must disclose a technical justification for that property. That justification could be in the form of scientific reasoning, as my learned friend has indicated, or it could be a disclosure of experimental data. But there must be something. The difference between us, I think the key difference between us in this case, or at least one of the key differences, is my learned friend says it's legitimate to engage in what I would call almost a parlour game, really, of asking the question, looking at the specification, and what has the patentee done which it has not disclosed? And that's, of course, essentially what we say his 3 gram point is. You notice the 3 grams and you say, oh, well, I could surmise what he's done. I could guess what he's done. But you might speculate there's been activity behind the scenes. You might not. But it's not part of the exercise that the patent system engages with. It's just not appropriate to expect the skilled person to speculate in this way. And it has no part to play in the analysis that my lords are engaged in today in our submission. We're concerned with what is expressly and possibly impliedly disclosed in the application as filed. We're not interested in clues as to what may or may not have been done. Before turning to the cases, which I'm going to come to very shortly, can I just remind my lords of the claims. They're set out in the judgment, probably the easiest place to get them, page 148. But the 2 claims that we're focusing on, as I understand it. Sorry, it's paragraph 148, I beg your pardon. Page 137. So, claim 1 is a compound per se claim. And my learned friends obviously been making the submissions. This is treated differently to a second medical use case. But we also need to keep in mind claim 7, which is set out in paragraph 149, which has a use limitation. So it's a compound of that structure for use in treating a thromboembolic disorder. So, as I understood, certainly my learned friend's case in his skeleton, is he was drawing a clear distinction. We can see that in paragraph 44, says that the judge was wrong to apply the law of plausibility as it did, and different considerations apply when you're dealing with a novel, and he says inventive compound, and claiming that. He's been silent. He's really not made detailed submissions on the use claims. So he's drawn a distinction on the one hand between the product per se claim, and on the other hand with the a second medical use claim, as what one saw in Warner-Lambert. He hasn't really explained his position with regards to claim 7, and we do not understand he could possibly be arguing, whatever he's arguing with respect to claim 1, we do not understand he could possibly even be putting forward a suggestion that the plausibility question on claim 7 isn't that it has to render plausible the use in treating a thromboembolic disorder, which appears in the claim. So there's a potential, and he's not really developed it, a potential that he's just running a slightly different case on claim 1. My lords will have in mind that below, a very different case was run on claim 1 to claim 7. That aspect is not pursued, but his point below was because it's a product per se claim, he doesn't have to show it's credible for the use in therapy. It's sufficient if he can show it's credible for other uses in the patent. And those were dealt with by the learned judge. It might just be worth, if the court doesn't have them in mind, having a look at those. That was dealt with at 224, I think, of the judgment. So there was a passage in the judgment, might just be worth having a look first at paragraphs 59 through to 69. We don't look at it in any detail, but that's where the learned judge, Justice Meade, was considering whether it was legitimate to look at other uses other than therapy, and he analysed Pharmacia and Merck and concluded at paragraph 68, I conclude that what it means for the invention to work is to be determined from the specification where the claim is not explicit, but that the patentee is not restricted to the most ambitious assertion made. In some cases, the patentee may be able to rely on a more limited contribution. And then he goes on to analyse that, paragraphs 2 to 4 of the judgment. So this was just for claim 1, because it didn't have the use limitation. And from 225 really, from 225 and 227 looks at standard or reference compounds. Were they made plausible? Was it plausible for diagnostic assays, plausible for anticoagulants, and so forth? That has all fallen away. That is no longer part of my learned friend's case. I just refer to that by way of background. But again, we invite the court to keep in mind that there are different claim forms in this case. We say, subject to the respondent's notice, we say the same principles are going to apply for each of those claims. My Lord, I'm going to start with Agrevo, which is tab 4. And see, my learned friends been to passages of this. Claim itself, again, in my learned friend's skeleton, is very much saying different considerations apply to product per se claims. We push back on that in our respondent's skeleton, but I just need to remind the court in each case, I think, which type of claim you're dealing with. This is a product per se claim, so credibility, plausibility was very much in play in this case. I accept my learned friend's point on breadth of claim, but it was a claim to triazole sulfonamides with the, as my Lord see on page 72 of the bundle. And then if one goes over to 2.3.1, that's on page 78, that was the prior art. So if you have a sort of finger in each, you can see the prior art was close structurally. That was, and these compounds were being put forward so as having herbicidal activity, so not a million miles away from where we are in this case. And then if one goes to 2.4.2, because it gets picked up later, the first sentence, the reason for this, it has long been a generally accepted legal principle that the extent of the patent monopoly should correspond to and be justified by the technical contribution to the art. And this is the consideration that frames all these cases in our submission. But we can then pick it up at 2.5. And there's a passage, if I could just ask my lords, just rather than read it out, to remind yourselves of 2.5 through to 2.5.3, up to where 201 of 80 is cited in 2.1.3. So, my Lord, some of the language is quite dense. It's reminiscent of some passages of Wittgenstein as to how they arrive at the position. But the upshot is, we see at the end of that, or in the middle of that paragraph on page 84, for the reasons that are provided, that in view of the underlying general legal principles set out in 2.4.2 above, the selection of compounds in order to be patentable must not be arbitrary, but must just be justified by hitherto unknown technical effect, which is caused by those structural features which distinguish the claimed compounds from the numerous other compounds. So the chemistry, the drawing out of new compounds for the reasons that have been given is not of itself inventive. What is inventive is the technical effect. And then they go on in 2.6, say, therefore, the board holds, contrary to the appellant's submission, the assessment of the technical contribution of the art must take account of the actual technical reason for providing the very compounds now being claimed, as distinct from the host of other theoretically possibly modified chemical compounds. In this respect, the description asserts that all claimed compounds do have herbicidal activity. Herbicidally active compounds, which are structurally similar to the claimed ones, since they are also triazole derivatives, are known from those documents. Any of these documents may therefore be the closest prior art. In view of this state of the art, the technical problem which the present patent application asserts to solve is the provision of further alternative chemical compounds with herbicidal activity. However, in the light of the board's finding in the point 2.4.3 above, this technical problem could only be taken into account if it could be accepted as having been solved. If in deciding the issue under Article 56 of the EPC would be credible that substantially all the compounds possess this activity, see also point 2.5.4 above. Accordingly, the board has examined whether this requirement is fulfilled, and in that case it wasn't. So I think there's nothing between us that the word credible and plausible amount to the same thing. And I accept my learned friend's observation that this was dealing with, of course, the breadth of claim, the credibility across the breadth of the claim. But we relied in particular to meet the suggestion in my learned friend's skeleton that a different standard is being applied in second medical use cases that, as to cases where you're dealing with a compound per se, a new compound per se. The issue is substantially the same one, as we will come and see when we get to Warner-Lambert. So then, the one other case I want to spend a little bit of time on from the EPO is in tab 21. That's dasatinib. That's and just ask you to note on the first page, 794, this is another BMS patent, and my lords will notice some similarities with the case we're concerned with. If my lords turn to page 800, you will see that the claim they've amended down to that compound. So it's a compound per se claim. It's a single compound. The compound is dasatinib, a single compound, all sorts thereof. And the application as filed was very broad, large marcouche, and it was amended down. Dasatinib, as we see, was one of 500 examples in that case. It was actually amended down during opposition proceedings 5 years after the PCT was published. If perhaps we then turn to page, so we're now in the decision, if we go to 812 and just pick it up at the bottom of the page, the application is directed to an extremely broad defined group of compounds of the following generic formulae, and then they're set out. And then you see at the top of 814, the application also discloses 580 compounds falling within the scope of the general formula, including dasatinib, which in that case was example 455. And then it says on page 39, line 10 to page 43, line 25, the application described a number of PTKs, that's protein tyrosine kinase, that was the target, which are potential targets of the claimed compound. And then if you could target that compound with your molecule from General Formula 1, you could have some clinical effects. And the clinical effects are mentioned a few lines down, as apparent from page 39 to 43, inhibition of specific protein tyrosine kinases associated with specific disorders. And then those disorders are listed. Then if we go over to 4.5, it says on page 50, line 4 to 53, line 18, the application refers to assays which can be employed in ascertaining the degree of activity of the compound, the test compound. The assays are generally described and refer to the protein kinase of interest and the test compound. No further details are provided in this respect, nor are any results, for example, IC or KI values provided. Indeed, there is no evidence at all in the application as far that shows any of the compounds falling within the scope of Formula 1, let alone dasatinib is active as an inhibitor for any of the specific protein tyrosine kinase, except an assertion, mere assertion on page 50, lines 1 to 2, which reads, compounds described in the following examples have been tested in one or more of these assays and have shown activity. And no further information is provided. And I'm dropping down a few lines. In the board's judgment, a mere verbal statement that compounds have been found active in the absence of any verifiable technical evidence is not sufficient to render it credible that the technical problem the application purports to solve is indeed solved. So again, we have similarities to this case, assertion, but for whatever reason, data not provided, data withheld, and then the mere assertion that the compounds are active were, in the board's view, not good enough. And then moving on to 816, bottom paragraph, even if the board were to accept the assertion on page 50 of the application as far as an indication that some tests have been carried out, no information is provided as to which of the structurally rather different compounds had been tested, and in which assays, in particular, whether any of the tests included dasatinib. So, of course, no two sets of facts are the same, but we say that's consistent with our interpretation of the law, not my learned friends. And then picking it up at 4.9, the board agrees with the appellant insofar as it is not always required to include experimental data or results in an application. It is, however, a conditio sine qua non that it is shown that the technical problem underlying the invention was at least plausibly solved at the filing date, if, as in the present case, the nature of the invention is such that it relies on a technical effect, which is neither self-evident nor predictable, or based on a conclusive theoretical concept. At least some technical evidence is required to show that a technical problem has indeed been solved. In the board's judgment, it is not acceptable to draw up a generic formula which covers millions of compounds, vaguely indicated as activity against PTA keys, leave it to the imagination of the skilled reader to, or to future investigations to establish which compounds inhibit which kinase, and is therefore suitable to treat with the respective diseases associated therewith. Then going back in time, and it's the other bundle, my lords, I was just going to look at John Hopkins. So there we had a claim to just been looking at a product per se claim, single molecule, and John Hopkins at tab 9. And we can see the claims on page 240, and it was a claim to instead of in the middle, it's sort of subclaims, so I think one can treat them as individual claims. So the first claim was a polynucleotide encoding a polypeptide selected from the group consisting of a polynucleotide having nucleic acid sequence ID number 3. So that was a product per se subclaim, as was the next one. But if you get down to D, you've got some functional features being introduced, which fragments cause growth and differentiation of oocytes, and ditto for E, set up in but we have effectively a single or extremely small class, if it's a class at all, in 1A of a product. And then if we pick it up at 246, this is looking at the prior art. So I'm jumping through this a little bit more quickly, but this was a discussion really of the the common general knowledge, and we see that at the end of paragraph 3, the skilled person, sorry, I'm just the last 4 lines of that paragraph. The skilled person was prepared to accept that a polypeptide belonged to the TGF-beta family if it exhibited this consensus sequence, even in the absence of any evidence as to its role. And then they say, starting from document 3, says prior art, the problem to be solved can be identified as isolating a further member of the TGF-beta superfamily. The solution provided is the polynucleotide sequence of ID number 3, encoding the polypeptide of sequence ID number 4, denoted GDF9. So those are then the claims, the first 2 inches of the claims we just looked at, first 2 subclaims. Whether or not the problem as defined in point 4 above has been plausibly solved, either whether or not it is plausible that the molecule as defined in point 5 above constitutes a further member of the TGF-beta superfamily, needs to be investigated. And that's what they go on to do. And then we can see them picking it up at the bottom of paragraph 8 on the next page, 3 lines up from the bottom. GDF9 cannot be clearly and unambiguously identified as a member of the TGF-beta superfamily by only using a structural approach. So that was the sequence wasn't there. Of course, the situation most probably be looked at differently if it had been demonstrated in the application as file that GDF9 played a role similar to that of the transforming factor B. Yet there is no evidence at all in this respect. So it wasn't plausible based on its structure, and it wasn't plausible based on any evidence. And then looking at the more well-known passage in paragraph 10, halfway down, says, at oral proceedings, I've got that, at oral proceedings, it was argued that speculations of this kind should be permitted because of the first-to-file approach of the European patent system, which forced the applicant to cover any and all subject matter connected with its invention. The board is unable to endorse this reasoning. On the contrary, in a first-to-file system, the earlier filing date of the application, not the date at which the invention was made, determines to whom several persons, having made an invention independently of each other, the right to a European patent belongs. And then if I could just invite my lords to read down to the end of that paragraph. And then finally, if I could invite you to just read paragraph 12 to yourself. Finally, last European authority I was going to go to, I mean, perhaps don't need to deal with it in any detail at all. It's just my learned friend mentioned it several times, so, which was Salk, which is at tab 8, which he placed particular emphasis on, but and there's nothing between us on the fact that in this case showing factor 10A activity, making that credible would have been sufficient on the facts of this case. It wasn't necessary to go into clinical trials and so forth. We're not disputing that today. But just, again, because of the distinction my learned friend draws, just to remind you, this wasn't a second medical use patent. One can see that, what the claims were on page 220. It was a method, there was a method for identifying compounds using have an impact on a steroid hormone-like hormone receptor. There's a series of steps set out. And then claim 6, which is at paragraph 222. I mean, these are not good claims, really. The use of a steroid hormone or steroid hormone analog is identified by the claim 1 to 5, which fails to promote transcription activity. So it was a use claim, but it was not a second medical use claim. in the sense it wasn't suggested that these steroid hormones were already in the art. Some of them may have been, some of them may not have been. My lords, I was then, sorry, I'm going at a pace I appreciate. I was then going to go to Warner Lambert.
Sorry, apart from drawing our attention to the claims and so on.
That was all, my lord.
Okay, fine, thank you. All right.
So Warner Lambert's at tab 22. And my lords, just have in mind paragraph. So my learned friend's shown you the claims on page 843. My lords will have in mind there's a record of the majority decision. It's quite a complicated case because once one tries to patchwork together who was finding what on all the plausibility and assumption, but there's a summary at the bottom of page 845, and we're going to also concentrate on the judgment of Lord Sumption. And then, as my learned friend has shown you, the Lord Sumption places reliance on this obligation of disclosure as part of the patent bargain, which he deals with over the page onto 847, all of which you've seen, but we do place reliance upon that. And then as to the citation from Exxon, he said the general legal principle, the extent of the monopoly as defined by the claim should correspond to the technical contribution to the art in order for it to be supported or justified. I mean, here we say, quite simply, my learned friend, if he were to have a contribution, we say he hasn't, but if he were to have one, it would be the identification that compounds had a specific factor in 10A activity. That is what his contribution can be, and that's what needs to be tested. And if it goes, if his claims extend beyond that, it's not justified by the claim, then his patent is invalid. And then and there was a reference to Lord Mance has expressed the view, this is at the bottom of 847. I think more exact to say that it's a statutory view, which is a fundamental to public interest that satisfies the issue of the patent. The contribution of the judges has been to work out principles which can be applied to Swiss form patents. The reference to section 14. And then it goes down, but the assumption is not correct in the case of a second amendment use patent. The invention is not the compound or the process of its manufacture. The skilled person already knows how to make the product from the prior art disclosed in the original patent. That's in the second context of second medical use. My lords, similar matters apply here because it's accepted, and indeed following Agrivo is not surprised it's been accepted. There's nothing inventive in the chemistry here, nothing inventive in the method of synthesis. So we say that for those reasons, there's no, again, one has to concentrate on the use that the compound is to be put to. Then there's a reference to armchair inventions and the concept of claiming too broadly. That was at paragraphs 22 and 23. Again, we just repeat the point that this is, as far as we're concerned, immaterial from an armchair invention, as we simply do not know if apixaban was tested. We can't know that from the specification. There's then a reference to John Hopkins, and then the question of labels is raised at paragraph 25, and I think my Lord Justice Arnold has already pointed out, as I was going to, that no point is being taken as to whether this falls correctly under the head of Agrivo obviousness or sufficiency, as in many other cases. That's not a distinction that's been necessary to pursue. Then, just to remind you, paragraph 30, I did see my learned friend, or I may have misunderstood his submissions, but he did appear to be reintroducing the implausibility as opposed to plausibility, and that's dealt with in paragraph 30. If I just remind my lords that that's rejected. The question, are you asking, is it inherently implausible? At this stage, that was rejected by the court in this case. And then I think my lords have seen and looked at in some detail the key passage in paragraph 36. And it's just not only important to notice the criteria which we say aren't satisfied in 37, which I'll come to, but first of all, the Lord Sumption picks up really what's been said in the Enlarged Board of Appeal, that plausibility is not a distinct condition. That's in the middle of the paragraph 36. It says, the principle is that the specification must disclose some reason for supposing that the implied assertion of efficacy in the claim is true, is one of substance. Plausibility is not a distinct condition of validity with a life of its own. And then he, dropping down a few lines, he says the test is relatively undemanding, but it cannot be deprived of all meaning or reduced, as Lord Justice Floyd's statement does, little more than a taste of good faith. Indeed, if the threshold were as low as he suggests, it would be unlikely to serve even the limited purpose that he assigns to it, barring speculative or armchair invention. Plausibility is not a term of art, and its content is inevitably influenced by the legal context. We agree with that. And then, of course, we rely, I won't read them out, but on the important propositions first, second, which my learned friends already drawn your attention to, is not made plausible by bare assertion. And we say that although this was a case that was concerned with second medical use claims, if one looks at goes back and looks at the cases to which reference is made, we've got Agrivo, the Satinib, Salk, it's plain that the Supreme Court were not treating second medical use claims separately in that respect. The law of plausibility which they draw on comes from a range of cases, John Hopkins, and they were not seeking, although, of course, in some passages are particularly relevant to second medical use claims, and particularly the infringement section, their reasoning is certainly, we say, binding on this court with respect to plausibility. Generally, that we say is part of the ratio of this case, and one can see that from the way the judgment is structured in the cases that have been relied upon by the court. My lords have seen the passages on data generated after the priority date. I think really the most important passage is the one on 857, because in that passage it's made clear that insofar as there's an exception, what that exception is, subsequent data may sometimes be admissible either to confirm that or to refute a challenger's contention that it does not actually work. But it cannot be a substitute for sufficient disclosure in the specification. And that's entirely consistent with the passages we've looked at in John Hopkins. And then there's the a passage my lords have looked at from 47 through to bottom of page 862, where that's developed. Well, the next one, we've probably got time to do this before the adjournment, is generics and Yada. That's tab 16. And this concerns a treatment for multiple sclerosis. My Lord Justice Arnold will remember this case. The claim is on page 424 of the bundle. And it was, you see it set out again, it was a product per se claim. No functional limitation. It was probably strictly a class of compounds, I expect, a relatively well-defined class. And there's a review of Revo from paragraph 40, and I think we can pick it up at paragraph 44, and then if we can pick it up at 433, paragraph 47. There's a reference to Dr. Reddy's. The Court of Appeal was concerned with rules which apply where a patent is sought for a compound or class of compounds which are a selection from a broader class disclosed by a prior document. Well, Justice Jacobs summarised the approach of the EPO to that question. Has the patentee made a novel, non-obvious technical advance and provided sufficient justification for it to be credible? This is the basis for the reasoning C.E.G. Agrevo. And then he goes, later he explained the basis, this is again referring to Lord Justice Jacob, explained the basis of the rule against arbitrary selection as being found in the guiding principle, is there a real technical advance? I would summarise the position as follows. Article 56 of the EPC is in part based on the underlying principle that the scope of the patent monopoly must be justified by the patentee's contribution to the art. And then, all important, but jumping down to 4, selection from the prior art, which is purely arbitrary and cannot be justified by some useful technical property, is likely to be held to be obvious. It does not make a real technical advance. A technical effect which is not rendered plausible by the patent specification may not be taken into account in assessing inventive step. And then just dropping down to 51, the judge recorded at 343 that there was no dispute that if the patent, when read with the skilled personal commentary or knowledge, did not disclose enough to make it plausible that the invention solved the technical problem, and that was the end of the matter. It was not permissible for the patentee to rely upon evidence which postdated the patent application, the patent to demonstrate the technical effect. My lords, I think that's probably all I need to do on that. My lord, I was going to move on to just a couple more cases, Idenics and then HGS. Is that a convenient moment for the court?
Certainly. We'll pause there and resume at 10:30 tomorrow.